we're here this afternoon on initial appearance. The law says you're presumed innocent. I want to go over your charges. I want to go over your rights and responsibilities. You're here on warrants that's been signed by Investigator Ogden of the Elmore County Sheriff's Office. He's charged you with burglary in the first degree. That is a Class A felony. If convicted, carries a possible sentence from 10 years to 99 or life. Possible fine up to $60,000. He's also charged you with attempted murder, 2 counts. Each of those are Class A felonies, and if convicted, carries with it a sentence with each case between 10 up to life, unless a deadly weapon is involved or dangerous instrument, then it's 20 to life on each count, and a possible fine of $60,000 on each count. And Investigator Evans of the Elmore County Sheriff's Office has charged you with the offense of robbery in the first degree. That is a Class A felony. If convicted, carries with it a possible sentence from 10 years to 99 or life, unless a deadly weapon is involved, then it's 20 years to 99 or life, and a possible fine of $60,000. On your first appearance in court, let me just ask you before I go over this, have you hired an attorney? And do you expect to hire an attorney? Okay. If that does happen, then that person would need to make, man or woman, need to make a notice of appearance. It's my reading and what I understand that you are indigent. I'm going to appoint Mr. Bill Lewis to represent you. This is Mr. Lewis. I think you've already spoken to him, haven't you, Mr. Lewis? Let me go over your rights and responsibilities. Number 1, you have the right to remain silent. Anything you say can and will be used against you in a court of law. Number 2, you have the right to an attorney. And I went ahead and appointed you an attorney, finding that you're indigent and you know what to do if that changes. You have the issue of bond. I'm going to address that in just a moment. Currently, you have a bond in the case of the robbery first of $100,000 with sufficient sureties. The attempted murder is $100,000 on each count with sufficient sureties, and $100,000 on the burglary first. So that would be a bond as of right now of $400,000. If at some point you're able to make bond and you do get out, a condition of bond would be the following: be in court each and every time your case is called or set. You cannot be arrested for any other criminal charge or charges. You must avoid even the appearance of criminal activity. You're not to leave the state without permission of the court. And you must immediately notify the court if you have a change of address. How are they going to know how to get in touch with you if your address changes? That would be your responsibility to let them know what your new address is. If you were to get out on bond and you were not to comply with every one of these conditions, then I want you to be aware your bond would be revoked. You'd be arrested. You have to stay in jail till your cases are over. I'm going to hear from the attorneys on the issue of bond in just a moment, but before I do that, let me just ask you, Mr. Dumas, do you understand the rights I have explained to you?
Yes, sir.
And do you have any questions about those rights? Mr. Houston, you wish to be heard.
Yes, sir. Your Honor, the state would ask that the bond be increased to $250,000 per count for a total of $1 million. And the reason being is Mr. Dumas is a repeat offender. I'm showing at least 3 prior felony convictions in his record. He's been formally charged with attempted murder and robbery first, and convicted of robbery first and assault first, and theft second. So he's got at least 3 prior felonies. And he has assaulted and preyed upon 2 elderly folks in the community who were trying to help him, people he's known for several years, is my understanding. They were trying to help him. There's no way they could have hurt him or would have hurt him. He took the money and he has seriously injured Miss Parker to the point that we're not sure if she's going to survive or not. So we're like that far away from a capital murder conviction. So we think with all of those 3 things combined justify a bond of $250,000 per count for an aggregate of $1 million.
Mr. Lewis, I'll give you a chance to respond to what Mr. Houston said.
Yes, I think in response to this, the bond schedule was set out in the code for these same offenses. He's charged with these specific offenses. They already exceed, the bond already exceed those numbers that are specified in the code. Based on that, consistent with the law, judge, we ask that you keep the bond that they are at this point, and ask for a bond opportunity with penalties and all that, and see if we can get it.
The court will set a bond hearing on this matter, and we'll give everybody an opportunity on both sides to be heard. If you want to bring family members, anything you want to bring, and we'll set that at the same time when we set the preliminary hearing. I agree with you, Mr. Lewis, that this is beyond the normal scale. It's set, especially set by one of our circuit judges based on, I believe, what happened in this case and what he understood.
convictions for something in one of these sounded very similar to this. Also, the indication that one of the victims, the first one, may be close to death. I will reconsider this at that moment if I need to, but right now I am going to raise the bond on each case to $250,000. Anything else, Mr. Lewis?
And Judge, I see what you're saying, this, the way the law is, Judge, basically, a bond that is that high basically amounts to no bond. And he's entitled to a bond. This isn't a capital case at this point. But it being $1 million, there's no way he can make it. But being that high amounts to no bond, that's what the court keeper has to do is do something like that.
Was he gonna be able to make a $400,000 bond?
He wouldn't even be able to make that, Judge. That's what we're gonna have to ask for a bond. But that $1 million basically amounts to having no bond, because it's so high.
It's kind of a moot issue, and we're gonna let you raise all those issues at the bond hearing, but I find that what I've heard about the 3 prior convictions, and he's presumed